I'm here this morning with Gil Sparks, who in the 1980s was the chairman of the Delaware Corporation Law Section and is probably the preeminent corporate law lawyer of my time, at least, if not of all time. Gil, I guess I want to start with trying to set the background to our discussion with regard to Section 203 of the corporation law by talking about the environment in the early 1980s. What was one of the most prominent concerns of practitioners like yourselves in the takeover era of the 1980s?
So I was basically representing corporate interests, either boards of directors or corporations. And I think the biggest concern of my clients, and by extension of myself, was that we had this very rapid development of the hostile tender offer. It had not really existed in any vibrant form until 1978 or so. There may have been some outliers before that. But it was being fueled both by new techniques and by a lot of leverage. We were in a period where there was a lot of relatively easy money in terms of the ability to borrow, largely stemming from, among other things, the deregulation of the savings and loan industry and the prominence of the junk bond phenomena. So that those who are intent on making a run at companies could fairly readily and credibly claim to have the money to make an acquisition. And these were generally entities, not one company taking over another, although there was some of that. But that was culturally, in the early 80s at least, still sort of taboo. It was more what we came to call raiders, people who would, in effect, get a line of credit fueled by junk bonds and then seek to take over companies, and either hoping to take them over, break them up, pay back their debt, and make money for themselves, or in some cases threatening to take them over, and companies realizing that it was wiser to buy them out, and then we had the green mail phenomenon where occasionally one of these raiders would sell their stock back to the company at a significant premium. The techniques that were being developed were ones that our law just hadn't kept up with or anticipated. So the most virulent of those, which was what was addressed later in the Unical case, was the front-end loaded two-tier tender offer, where someone would go out and raise the money to make an offer for 51% of the stock at price A, and then say, once we get control of the company, we'll cash out the minority with a note that they would claim would be of the same value as the front end, but generally was thought not to be, and to be risky. And then once they got hold of the company, they would sell things in order to pay back the principal and interest on the note and pay back the money they had borrowed on the front end, so that when the smoke had cleared, the company would be smaller. There would be the risk that employment would be lost, and that was bothering a lot of companies. And it wasn't the idea that we are going to go after poorly managed companies. It was, no matter who you were susceptible to this type of raid, if you will. And it didn't really make any difference because there was so much money around as to how big you were. It did make a difference, and much of this activity happened in the oil industry, where values of companies and their reserves were premised on what they had in the ground, and it was just it was an area of intense activity. Much of this activity in the early 80s being focused on city service, Unical, Gulf. There were just a whole series of these raids, if you will.
Okay, well, we were focusing a little bit on the 1980s, but even before then, there was a version of Section 203 that I think was passed in 1976. that was an attempt to deal with some of these takeover issues. What was the background? What happened to the original version of Section 203?
So the original Section 203 basically required that if you were a tender offeror, before you could start your offer, you had to give 20 days notice to the state officials before you could commence. That type of statute was, and that was against a backdrop where the federal law at the time allowed a tender offer to commence and be finished in 10 days under the Williams Act. That type of statute was ruled by the Supreme Court in the Might case in 1982 to be unconstitutional. Now, the Might case, if you go back and look at it, and this is obviously the case in lots of Supreme Court cases, had an unusual number of concurring opinions going off on different theories. A plurality of the court concluded that the Indiana statute, which was in question in Might, the Illinois statute, which was in Illinois or Indiana, I don't remember which one it was, but the statute that was in question in Might was in violation of the Supremacy Clause because the Williams Act sort of occupied the field and it had a different time schedule than the Williams Act. The majority found that it violated the Commerce Clause. And while the statute that was in question wasn't exactly like the Delaware statute, it had some features that were different to the Delaware statute. It tried to regulate not only companies that were incorporated in the state, but also principal place of business or where most of the stockholders were. And it had also a fairness hearing that the state could have during that 20-day period. Our statute didn't have that, but our statute did have the 20-day advance notice provision. And the general thinking was that it was unconstitutional. And indeed, it had gotten to the point where it was routine for people to go in and get summary orders from the federal district court declaring it to be unconstitutional. And that became such a nuisance that ultimately the federal court asked the corporation law section to put in a piece of legislation repealing this first generation 1976 statute, which by the time we get to 203 had already been repealed. So it was off the books. It was ineffective. So that's where things stood as of roughly 1982 when the Might case came out.
Yeah, I remember those days because I remember going over to federal court and getting yelled at by, I think it was Judge Swartz,
right.
for having shown up six
times.
times.
Six times to get, yeah. I mean, it was just sort of like routinely you'd file a complaint, you'd go over, the judge would knock the thing out, and you'd be on. And they finally got sick of it and said, this thing's clearly unconstitutional. Just would you please repeal it so we don't get bothered anymore? But,
Okay. Well, even apart from the statutory attempts to deal with the takeover phenomena, we know that in, I guess it was 1985, the Unical decision was decided. And how did that, as a general matter, fit into this whole situation where people were attempting to deal with hostile takeovers?
So the Unical decision made it clear that as a matter of Delaware law, the board of directors could intervene, if you will, to protect stockholders against an attack, if you will, using the most coercive of these techniques, which was the front-end loaded two-tier tender offer. It held that the business and affairs of a Delaware corporation, which Section 141A says should be managed by the board, included the stockholders, and that the board was not to be passive, but in appropriate circumstances could take action at the corporate level to protect those shareholders. So the Supreme Court was trying to fill this void a little bit.
Delaware Supreme
Court by changing or expanding the common law to make it clear that the board's function was not simply internal affairs, or another way of putting it is that the stockholders were part of the internal of internal affairs. The other development that happened somewhere between, or somewhere in the early 80s, was the Williams Act did get amended to expand the time that tender offers had to be open from 10 to 20 days. That took a little bit of the pressure off from what were really the Wild West days of the late 70s and very early 80s. And so as we head in toward the season, and there's of course one other significant development, that's 1985, 86, which was the ultimate approval by the Delaware Supreme Court of what we have come to know as the poison pill, or the rights plan, as it was technically called, which was another device used to slow down the process and, in the most egregious circumstances, to prevent some of these more leveraged predatory techniques. So we get to, by the time we're getting to 1987, which is the time we're going to, 87, 88, which is the period of time that we're going to be focusing on here this morning. You've had some developments already. Things have moved. You've probably also had a better understanding by the U.S. Supreme Court of some of these techniques, which were in their infancy when they decided Edgar versus Might back in 1982. And so we will probably next move to talk about the next landmark decision in the U.S. Supreme Court.
In 1987, the U.S. Supreme Court decided the CTS case, and how did that have an impact on the corporate law developments in this area?
So the CTS case dealt with something called a control share acquisition statute, and the concept was, I think it was an Indiana statute, and the concept was that if you were going to acquire more than a particular percentage of shares, then before you could vote them, you had to have a vote of the stockholders to approve the acquirer, if you will. And so that went up for a constitutional test. And in a case that the tone was quite different than Edgar versus Might, the Supreme Court found that passed the test of constitutionality. That was also limited to the exercise of that power by domestic corporations. So it didn't have the effort to sort of reach out to regulate corporations other than the state where the statute was passed. And that lent new encouragement, especially to us, that there might be some room for state regulation in this area. In the meantime, there had been a lot of activity since 1982 in Edgar versus Might in other states. So by the time we get to 1987, there were, the number keeps getting repeated in our deliberations. There were roughly 27 states that had passed second generation anti-takeover statutes. In other words, statutes that were an effort to avoid the pitfalls that had befallen Edgar versus Might. And this, of course, this Indiana statute we're talking about was just one of them.
Okay, well, we know that CTS case was in 1987, and I guess in the Delaware area, it seemed to me that by June or so of 1987, you and the other people on the corporate council began to focus on specific Delaware legislation. Do you remember the initial attempt to draft such legislation, and what did it involve?
Well, the initial attempt was basically one pattern after the one that had survived in the CTS case. It was a controlled share acquisition statute, and it surfaced in late May. I think teed up for a meeting of the Corporation Law Council in June, and I do not have a distinct recollection of the discussion and debate, but I can tell you that by inference, it was met with disapproval, and it disappeared from the scene, and work began to try to find a different model. While this was all going on, there was a political overlay to this. The administration, the Castle administration that was in place at the time, and the Secretary of State, Mike Harkins, were also being pretty insistent that they feared that with CTS and with 27 other states out there having passed some form of anti-takeover legislation, that we had to do something, that competitively it was appropriate for Delaware to do something. And I think the sense of the bar was, I know my sense was, well, okay, we may have to do something, but we ought to try to be a leader here and come up with something that is acceptable to all constituencies, that we had the ground, we had enough of a sort of a economic lead in this area that we could afford to be trendsetters and try to come up with something that was that didn't stop all takeovers, that did address the abusive techniques, and that was as balanced as it could possibly be. And I think that was what we then turned to in terms of trying to come up with something that made sense within those parameters.
Yeah, and I know that there was a committee appointed, and I know that from June of 1987 through the fall, they
Right.
were focusing on ways to come up with a new and better statute.
Right.
For example, there was a council meeting in October of 1987 where a particular statute was first, I think, put on the table, if you will. What were the principal subjects of debate about this new version of Section 203?
So the version of 203 that we came up with was, the basic structure was, if you acquired a majority of stock, or if you acquired stock in a tender offer, let's focus on the tender offer aspect. There are other aspects of it, but focus on the tender offer. That you ought to have to acquire enough of it to be comfortable that the price that you paid and the structure of the offer were fair. And so the debate was, and the structure that began to take place was, all right, where do you start? What's the low number that triggers an obligation under this statute, and what is the percentage of stock that we can use as the upper level to say, all right, if you exceed that percentage, then we're not going to bother you with this statute, that we're going to assume that the structure is okay, because by definition, the numbers we were talking about were in the range of 75 to 90%, so that would have meant it couldn't possibly have been a front-end loaded two-tier tender offer, which always was sort of at 51. But also, it was a number that we thought would be high enough that you couldn't really debate whether the offer was fair. It might not be the highest price you could pay, or it should be paid, but it was high enough that it would have to interest a large enough percentage of stockholders that you could be pretty sure it was fair. And the penalty for not complying, for going over whatever the lower percentage was without permission, and you could get permission, by the way, from among other things, from the board of directors, was that the buyer couldn't do any transaction with the company that they had bought for 3 years.
How many years?
3.
3.
And what that meant was, well, it had other ramifications, but what it really meant was you couldn't use the assets of the company to pay back your acquisition debt, so that it would have been a deterrent to these highly leveraged tender offers that we discussed a moment ago in reviewing the climate at the beginning of the 1980s. So, and the model that we came up with, my recollection is that the model we came up with in October had in draft, had a 10% limit at the bottom and a 90% limit at the top, which meant that if you exceeded 10% without getting board approval, or without going above 90% in a tender offer and getting over 90%, then you were going to be subject to this 3-year moratorium, which is why these things were called moratorium statutes. The other decision that we made was that this was such a hot button topic for both in the intellectual, academic, and lawyer world, but also in the world of the corporations that were domiciled in Delaware, that we were going to have as open and transparent a process as we could possibly have. And so this draft was deliberately made public, and each member of the Corporation Law Council was encouraged to send it to clients, to other corporate lawyers in other major jurisdictions that they knew would have an interest, and to solicit comment and reaction from all of them. And as a result of that, we got a flood of comments, positive and negative, from a large variety of sources.
Including academics and even the federal government, isn't
Well,
that
we got a particularly active in this area was in terms of commenting was Joe Grunfest, who at that point, having left Stanford as an academic, was then sitting as a commissioner of the Securities and Exchange Commission. And while he went out of his way appropriately to say that the views he expressed were not those of the commission, but were his individually, nonetheless, all of his correspondence came on a letterhead from the Securities and Exchange Commission. So it was.
You got the message, did you?
Well, we got a message. I to this day I have no idea whether he spoke for anybody else, but he was certainly a contributor to be reckoned with, if you will, and an intelligent one at that. And we paid attention. We paid attention to all of the comments that we got. I would say the most, in terms of out-of-state people, the other most vocal person, although I'm not sure he wrote a letter, but we knew what his position was Marty Lipton at Wachtell Lipton. And in terms of putting a concrete number on it, the range of when I mentioned the 90% number, I think Marty Lipton might have preferred it be 95.
If not 99, probably.
Yes, and in his most conservative position, Grunfest would have preferred it be 75, and beyond that there was discussion about what the numerator and denominator should be. So whether or not, in counting whether it was 90 or 85 or 75 or 80, whatever the number was, whether that upper number should or should not include director shares, officer shares, management shares, and shares held by ESOPs. And as time went on, and we sorted through all of these comments, there was a movement in both ends. So the 10% ended up going to 15. So you could buy up to 14.9% and not be grabbed by this statute. And the 90 went down to 85, and also I think it always had excluded management shares, officer shares, but it also was changed to exclude shares in employee stock option plans where where management in effect had the right to vote those shares, and so in effect it went from 90 to something below 85 if you assume a constant picture. That notwithstanding that, the debate over what that upper number was continued. There was also some debate about another override in the statute. I mentioned that the board could approve the interested stockholder before he got to the 10 or 15%. It turned out to be 15. But there was also a provision that said that if somebody went ahead and acquired, that if 66 2/3% of the disinterested shareholders, i.e. those that were left, voted to relieve the acquirer of the burdens of the statute, that was okay. There were some who wished that that number be 50% instead of 66 2/3%. And then finally, the other thing that I recall being a hot button point, but really not until we got to the very end and actually were dealing with the legislature, although it became a point for Grunfest and others, was whether the statute ought to be opt-in, where you would have to put it to a vote of your stockholders to be covered by it, or whether it should be opt-out, in which case you could choose in various time periods, either by director action or stockholder action, to remove yourself from the coverage of the statute.
All right, I want to go back just for a moment to the debate over the upper percentage, what became the 85%,
Right.
so that I can understand why that was important. Does that number have any effect on the ability of an acquirer, a legitimate acquirer, to conduct a tender offer? Would this, in effect, if the number discourage all tender offers?
Well, that was the debate. What was the number that we all felt comfortable with that would allow well-priced, structurally any and all well-priced offers to succeed? Because we didn't want to stop them. And there wasn't a lot of literature on it. To this day, I don't think anybody, there's a lot of literature on it. But the idea was to try to come up with a number that makes fully priced tender offers, excluding management shares, excluding these ESOP shares, attainable. At the same time, not allowing structurally deficient offers like front-end loaded two-tier offers or grossly inadequate offers to go forward. That was the idea. And there were, among the people who commented at one point, I think Professor Grunfest grudgingly would have said, well, okay, maybe if you take the ESOP shares out, and maybe if you take out some of the other shares that maybe 85% might work. But then again, he'd prefer 80, and then he never really withdrew from the field. He was arguing for 80 or even 75 right up until the end. But part of the movement was in the direction of listening to him. You have on the other side, you had Marty Lipton saying, if you do 85, you've done a meaningless thing. And so we did the best we could, listening to all of this and looking and trying to look at what other how offers that were fully priced had actually done in the market, and we're able to see that
I want to focus on that because
I mean, don't forget, we'll come back for a second. We have a statute that says 90% allows you to do a short form merger. I think we all knew that there have been lots of short form mergers over time, which meant that you had gotten over 90% in a fully priced offer. I think in my thinking, that was why I think we came up with a 90% originally, because it matched the short form merger, and everybody knew, I mean, nobody did a study, but everybody knew that there were lots of short form mergers that had gotten done over time. So somewhere along the line, there had been tender offers that had gotten over 90%. But we started to listen to some of this, well, what about ESOPs? And they control the ESOP, and you'll never be able to get there. And there'll be people who are lost and never respond and don't tender. And what are you going to do about that? And then what about the director? What about the management people who have all these options and then have a lot of stock? And are you going to allow them to, in effect, make the 90% really 95%? So we moved in both of those areas, but with some level of comfort because of the experience we had had with short-form tenders in the first, for short-term mergers in the first. Short-form mergers.
You may remember. Let me just briefly show you this December 18, 1987 letter from Commissioner Grunfest. What struck me about the letter was the amount of detail he provides throughout that letter about various studies dealing with this whole question of what percentage would be possibly successful and what percentage would be so high as to be preclusive. And you'll note in there that later on he goes through table after table talking about these various percentages.
Right.
And so it wasn't something that you were just dealing with in
No,
a vacuum.
no, we had a lot. We had information, and this wasn't the only information that we had, but we certainly had information designed to give us, which gave us some level of comfort in an area where you're never going to know precisely what the number is. But yeah, we did have the benefit of his thinking.
All right. Now, let's talk a little bit then. After you had gotten all of these comments, you mentioned there were several other debates that came up later, but before we get to that,
Right.
there was, I believe, a very active debate at the Corporation Law Council section. What was the function of the Corporation Law Council in dealing with Delaware legislation, so people can understand why there was a debate?
So the Delaware Corporation Law Council is basically a committee of the corporation law section. The corporation law section is a portion of the Delaware State Bar Association. Anybody who wants to check the box, who's a member of the Delaware Bar, can be a member of the corporation law section. The Corporation Law Council is elected by the members of the section, and it's a working group of, I think, roughly a dozen people, all of whom are either corporate lawyers or corporate litigators, usually has representation from the plaintiff's bar, from the defendant corporate bar, and just people who are in-house corporate lawyers. Occasionally, it's even had some in-house general counsel for companies that are actually located in Delaware. It did not at this particular point in time we're talking about. And they work year-round to fashion legislation that hopefully gets passed by the Delaware legislature in response to changes that are going on and are constantly going on in the corporate world, both financing changes and new developments that are happening everywhere. Also keeping an eye on developments that others have thought about that may have merit, like the Model Business Corporation Act people or other states, and whether something they've thought of is worthy of being considered in Delaware. So they draft. And then ultimately vote on, and what they vote on is to pass on a recommendation to the executive committee of the Bar Association. And there are other committees or other councils, or the Corporation Law Council isn't the only one in the section, and the executive committee passes on approves or disapproves recommendations coming from all of these entities, and in this instance, of course, from the Corporation Law Council. Once the executive committee approves something, and there's an intervening step, there's a vote. There's actually a vote, like an annual meeting of the section or a special meeting of the section to approve something. Once it gets through that step, then it goes on to the executive committee, and the executive committee can then authorize the submission of legislation to the legislature, or they can veto it and say, well, we're not going to do it, we're not persuaded, and we're not going to go forward. So there are multiple layers of approval before you ever get to the legislature. There's the approval at the council, there's approval by a vote of the section at large, there's approval by the executive committee, and only then does the matter get passed on, in effect, to the lobbyist for the Delaware Bar Association down in Dover to be presented to the legislature.
All right. Now, when this legislation was presented just to the council, was the vote unanimous, or was there some dissent?
The only dissent I recall is Charlie Richards from Richards, Lane and Finger.
And his concern was that this would kill or hurt tender offers?
He actually ended up at the end writing a letter, I think it's dated December 30th or something like that, explaining his position. And when he really comes right down to it, he was saying, well, if this was 80% instead of 85%, I might be in favor of it. And I believe he maybe had another objection. He wanted a majority of the disinterested, not the 66 2/3. Those were the 2 points he made that he said, if that were changed, he could vote for it, but otherwise he thought it was too restrictive, and he would not. And so it was almost unanimous, but not quite.
Not quite. All right, now, we're now at the end of 1987, or thereabouts. Soon after that, it passes through the process that you just talked about.
Not without a lot of explanation, including some work that you did to make clear what it was we were trying to do. But it did ultimately get approved by the section, and then it got approved by the executive committee.
Then in the past, and that is before this legislation, was it generally true that the corporation law amendments met with little resistance at the General Assembly level?
That is generally true. I mean, there have been and subsequently some controversial matters, but generally the legislature respected the fact that the people who are proposing these changes, the sort of annual changes, were accomplished Delaware lawyers whose interest paralleled that of the state, and that they were anxious to make sure we had a credible corporate law that would continue to retain and attract major corporate clients, all against the background of the fact that over the course of time, the corporate franchise tax and now the corporate franchise tax plus the estate benefits have compromised anywhere from 20 to almost 30% of the state's revenue. So it was not in the interest of a legislator to take action contrary to the recommendations of the corporate bar, and the corporate bar obviously had the same interest in making sure that these major corporations continued to, and not even just major ones, but all corporations continued to view Delaware as a fair and appropriate place to work. At the same time, all of us, Corporation Law Council, I think the legislature, all of us were also concerned that whatever we did be balanced and not run the risk of the other risk of losing this corporate business, and that would be that if the Delaware way of dealing with things became inappropriate in some way of unduly favoring management over investors, or in some other way that the federal government was always free to move in and take over this whole area of the law. And so there were always constraints, and there was always the sense in the council, which was particularly true here, that we could afford to try to do things, quote unquote, right. We didn't have the pressures that some other states had, where they had one or two very major corporations that were incorporated there, and they could basically call shots. We weren't under that type of pressure. We had this synergistic alignment of interest with the state, and the philosophy, certainly while I was there, but I think it's continued, was the best way to maintain that is to just do the best intellectual job we can and making sure we're running a fair and balanced system that doesn't unduly favor either management or investors, that it works for everybody.
Yeah, and I sensed that you, the correspondence and all of the letters just prove you're 100% right on that. There was, however, some opposition to this legislation from the Delaware business community. For example, I seem to recall a letter from the then president of Wilmington Trust Company, initially at least opposing the legislation. Wasn't that also a problem at this point?
Well, I think the overwhelming, and I don't remember the Wilmington Trust letter in particular, but the overwhelming support of the Delaware business community was, they were overwhelmingly in favor. And there was testimony from the CEO of Hercules before the Senate. We had a joint hearing between the Senate and the House. There was, DuPont was in favor of it. Conagra was in favor of it. Pretty much everybody, and I think even Wilmington Trust, my guess is we had a chance to discuss it with them, and I think even they came around in the end. But the support from the Delaware business community was, so far as I could tell, unanimous as time went on. And There was also support, which is important in this state and in our legislature. There was support from organized labor. They saw these hostile, coercive tender offer, breakup type tender offers as endangering employment, as it had done in other states where there had been some success in these areas, and the companies had been hollowed out as they had to sell divisions to pay down debt, and large numbers of employees had lost their jobs, and so they were in favor of it. So we had a lot of natural constituencies that ended up being in favor of it. That didn't mean that there weren't questions appropriately about some of these percentages and the like, and because this was new turf. But the legislature sort of took the same tack that the Bar Association had taken, and had 2 days of open hearings where people were invited to make written submissions and to appear on the floor of a joint hearings of the House and the Senate to move this along. All the while, we were being encouraged to push forward and had the full support of the Castle administration, who very much wanted to get something done to avoid the risk that if we just did nothing, that some one of these 27 other states, and perhaps others who would follow them, would be an attractive home in the sense that we just hadn't done anything and should have done something in response to these tactics that were then prevalent.
All right, well, before we get into the legislative process, which in this particular case is very interesting, I do want to circle back just a little bit to the opposition to the legislation. I seem to recall that some of the opposition came from pension funds who were concerned that this kind of legislation would prevent them from recognizing or realizing increased value to their holdings of corporate stock, so they wouldn't be able to sell at a higher price because tender offers would cease to exist. Was that the kind of economic analysis that you had to deal with?
Well, we did have to deal with some of that. There was fortunately a law professor at Northeastern named Donald Margata who had actually studied this area and looked at two sets of statutes, New York and New Jersey, which were significantly more restrictive than what Delaware was proposing. And he had concluded that there was no material adverse market reaction to the adoption of these things. And so we had that in our quiver, and we responded to those arguments as time went on. I think ultimately that Delaware, whoever was Daneman, I think, was the guy who was running the Delaware pension system at the time, and I believe he ended up testifying in favor of this. He had looked at it, and so ultimately that did not become it was an argument that the opposition raised. The one that was the most interesting to me, because it was dramatic, was there was a group called the United Shareholders. They had been organized, as I recall, by Mr. Pickens, but he had gotten a bunch of other people to sign up, and so they were a standalone organization. They put in a letter, and that letter basically tried to take in part the position that management of U.S. corporations were a bunch of fat cats playing golf and riding around on yachts, and that corporations were mismanaged, and therefore tender offers were a good thing, and we ought to get rid of these people, and we ought to, in effect, have Delaware do nothing.
You say put in a letter. He put it into the General Assembly?
To the General Assembly.
All right, well, let's just take this one step at a time, because it's really at least very interesting, particularly because it's so, at least at that point in time, unique.
Right.
I mean, you, as our representative, had to go down to the General Assembly and actually not just send them memos, which you did in abundance,
yes.
but also to appear
yes.
and be questioned by the legislators. Legislators, excuse me. Can you tell us a little bit about the process that you had to go through?
So that was actually a series of processes. I appeared before both the Democratic and the Republican caucuses to answer their questions in the closed sessions. In each case, I provided them with memos that were designed to highlight the principal points, the 5 or 6 points they ought to really focus on. I had been advised in terms of technique for doing that by my partner Frank Biondi, who was more than familiar with dealing with both caucuses in our legislature, and he said, you know, we ought to have bullet points. You ought to get right to the point, and so I fashioned my written materials to them in that way. I went down and spoke to all of them. I subsequently testified at the joint hearings, and then in the actual day when the bill was passed, there was debate on the floor among the legislators in the House, and Representative Oberle had put in an amendment that would have made a House bill an opt-in bill. And after Representative Hebner, who was sort of leading the charge in terms of the House and getting this passed, made some comments, he then said, and I'd be happy to have Mr. Sparks come and speak at more depth. I was then allowed to be a witness, if you will, and engaged in, I think, about a 20-minute debate with Representative Oberle about why it is that we couldn't do an opt-in bill as distinguished from an opt-out bill. So all of that activity was going on. Plus, as you mentioned, there were letters coming in that we would see also that would make points. And I know I had a letter to Senator Knox. I had letters to others that would say, this is what this person has just written to you. These are the facts, and then I would give them a 3 or 4 page or 2 or 3 page bullet point refutation, if you will. So this was in the period roughly from January 10th to January 26th. There was this constant activity, some of it in person, some of it with memos, some of it with memos and in person, that I was the point person for, and trying to make sure that all the questions were answered, that we got this thing done.
You weren't the only one there, however. Isn't it true that there were opponents who also appeared at the legislature?
At the hearings, absolutely. Grunfest testified, Commissioner Grunfest testified, others testified.
Did Mr. Pickens appear?
At the end. My recollection is, I was there, I saw him come in with his wife to Legislative Hall, and I believe it was on the 26th when it was actually passed. I didn't see what he did there because I was testifying on the floor of the House, as I just described, and he was over doing something in the Senate. So you're going to have to ask somebody else who knows what he was doing, what happened over there. Going back to the House for a minute, we got a little off track, but remember the United Shareholders letter that I mentioned? And it made these attacks on management as being a sort of a class of golfers and yachters and not really running businesses appropriately. Hebner, Representative Hebner, got up and he said, you know, think about this. You've gotten this letter. Think about the CEOs that we know. He said, think about Irv Shapiro, Jefferson and Heckert from DuPont. Think about Bob Barnett. Think about Cordays. Think about Jocko from Hercules. He says, none of these people fit this image that this letter lays out. And I remember that very, very distinctly. I've since read the transcript, but that was a memory it was shortly after that we started having. I think there were like 6 or 7 amendments that were attempted to be put into the House. I mean, this was going right down to the wire. And it was right after that I got put on the floor and had my discussion with Representative Oberle, who in the end, supposedly persuaded by what Representative Hebner and I had said, dropped his opposition to the bill and dropped his 4 amendments or something like that, and the House went through. I then, after that was over, I have this recollection of being in the hall of Legislative Hall, waiting for the Senate vote. And somebody came up to me, I think it was Secretary of State Harkin, and said, "They're voting. You got to get in there." And I went into the Senate chamber, into the spectator area, and the vote had already happened. And I was told that that Senator Sharp was irritated at the presence of Mr. Pickens, who had come in not at the hearings, which were a week before, but apparently had showed up on the day of the vote. And I have no idea what he said or whether he was given the floor or what happened. But apparently Sharp had enough, and he called for a very snap vote, and it passed. I can't remember if it was 14-2 or 15-1. I simply remember that Senator McDowell was opposed, as he had been throughout, and he was probably in terms of the spectrum, the furthest left of the various senators, and he just wasn't interested in this legislation.
I want to just touch on one thing you mentioned because I want to make it clearer. You've talked about the debate of an opt-in versus an opt-out.
Yes.
What does that exactly mean?
So the question was, would the statute apply automatically with some ability of corporations, if they wanted to take action either at the board of directors level or by a vote of stockholders that the board would call for to remove themselves from the statute? Or would the statute be more like 102B7 was, where you had to have some form of vote, charter amendment or something else, to activate the statute? And and part of the debate was, well, we had opt-in for 102B7. Why doesn't that work here?
That's what I was going to ask you, the very question.
And the answer was, there were a number of answers to it, but the main answer was, look, if you ask corporations to put this before their stockholders, they are just asking to be put into play. That you're going to say, all right, now you're going to have. Now we're going to put this up for stockholders, and we would just have a myriad of proxy contests. But basically, you would by asking for it, it was a little like similar to adopting a poison pill. You would draw attention to yourself and increase the risk that you would be put into play. And does anybody want to run a risk of that with respect to DuPont or Hercules or Conagra or any of the other corporations? With a major presence in Delaware, to say nothing of all the other corporations who are paying maximum $130,000 franchise tax at the time. And if you're going to have that vote, it's a reincorporation vote is just as easy. So if you're going to force them to have that vote, how do you know instead they aren't going to choose to have a reincorporation vote to one of the 27 other states that have acted in this area?
Now, it's hard for us to remember the atmosphere in late 1987, but it was at that time in October of 1987 that there was a stock market crash.
There was.
Did that atmosphere have any effect on this whole process, particularly on stockholder value concerns?
It did in the following sense that I can recall, and that is that to the extent that people like United Shareholders and others were saying we ought to have a wide open takeover market, and these aggressive techniques were okay because corporations are generally mismanaged in this country, which was part of the theme. The answer, and I know I gave this answer at one point in one of these debates, is, look, DuPont stock fell 30% in the October 19 break in the market, putting up a red flag and making it an attractive potential takeover target because its value had been diminished as compared to what its real value was, if you will. It didn't have anything to do with mismanagement. They didn't do anything, just like all the other corporations whose stock fell 30%. They didn't do any mismanagement in the week before the October 19th of 1987, but they were certainly vulnerable during that period. And do you want to expose? And so it belies the theory that the only way companies can become undervalued is by mismanagement. They can become undervalued by market functions also.
All right, now after the legislation passed, was it upheld as constitutional?
It was. I know I was called upon. I think what the Secretary of State did, as Delaware was a defendant in a number of these cases, they would obviously have a corporate defendant challenging the constitutionality of this, but Delaware would intervene and be allowed to be heard. I know I went up and argued one case, I can't remember what the name of it was, before Judge Sands in the Southern District of New York to defend the statute representing the state of Delaware. I believe that the state made an effort to pass that business of defending the state around, so I suspect most of the other major law firms also got an opportunity at one point or another to go
Follow your lead, right?
Well, to go and defend, but those efforts were all uniformly successful, and after a while, attacks on the constitutionality of Section 203 abated. A couple of years ago, Professor Subramanian at Harvard nonetheless decided to intellectually that maybe there was a constitutional problem with Section 207. I was sort of pulled out of retirement to debate him a couple of times.
You said 207.
I'm 203.
Okay.
I was called upon out of retirement to debate him a couple of times. It was fun, but I think he's sort of since dropped that as his intellectual interest. I think I've convinced myself that those cases were all right, and it has no constitutional impediment. And I think we were pretty confident of that also at the time that we passed it.
All right, well, we know over the years, of course, various new tactics have come up, particularly by activists. But has Section 203 had a lasting beneficial impact in your mind?
Well, interestingly, I think for a period of time it probably didn't. And I think now it probably does have an impact. So let me explain that rather strange comment. Right about the time, I mean, we know that in this same period we had just had Moran versus Household approving the rights plan. The rights plans are very similar in some ways to Section 203, except obviously they're private documents. They're not a statute. But they have the same concept of if you go over a certain percentage, usually 15, sometimes 20, that
Percentage of ownership.
Percentage of ownership, that you can trigger the pill and face possible dilution. In those cases, the penalty is dilution rather than a moratorium, but same deterrent effect. And so for a number of years after 207 was passed, 203 was passed. I guess 7 is coming in here. After 203 was passed, most companies who were at all vulnerable passed or adopted rights plans. And I think you could fairly argue during that period that while you had to comply with the provisions of Section 203, they really you were going to get bitten by the poison pill anyway, and so it was redundant, if you will. In recent years, under some pressure from activists and as people got more comfortable with rights plans and the fact that they were going to be able to put them in the heat of battle, many corporations have allowed their rights plans to terminate, if you will, recognizing that if there actually were a hostile tender offer, they could always put one back in to deal with it. Either if they decided to remain independent, to stand behind it, or if they decided ultimately to sell the company, to in effect regulate the sale process in a fair way. The effect of that is to leave companies vulnerable to one aspect of the protection that the rights plan gave you beyond dealing with the tender offer itself, and that is the creeping tender offer. That is the person who in the market goes out and buys 15, 20, 25%. You wake up one day and you say, this person's got effective control, and I've let it happen without extracting from the rest of my shareholders their share of the control premium that is now passed to this person. The rights plan stops that. The rights plan, the 203 stops that. 203 in effect is a protection against creepers. And it's out there performing that function, and it's what allows corporations to decide to put their rights plan on the shelf rather than have it keeping it evergreen. So to go back to the beginning of my comment, I think there was a period where 203 was sort of surplusage. Obviously, it wasn't surplusage if somebody did not have a pill, but it was. But since most people did, it was surplusage. Now I think it performs an anti-creeping function that is more vigorous than it was 10 years ago, 5 years ago.
All right. Well, so tell us what other states did in comparison to 203.
So we've talked about the Indiana version, which was what passed muster ultimately in the CTS case, which was a control share acquisition statute, and basically says no voting rights unless approved by shareholders. There are other constituency statutes that were passed by some states where basically the board, in deciding what to do with respect to a hostile offer, was permitted to consider not only the interests of shareholders, but also the interests of the community, suppliers, employees, et cetera. That was basically a reaction to how some people read the Revlon case, and it dealt with what you would do when you were selling the company. Delaware is vigorously and allows you to consider all those things in any other context, so long as it's rationally related to the shareholder interest. But when there was going to be no future shareholder interest, obviously, Revlon said you can't, and this was an attempt to back off on that. There were fair price statutes, which basically say that the second step of a tender offer has to be at the same price as the first step. There is a variant on that, which we call a control share cash out, where you get a right to redeem your stock if somebody makes a first step tender offer without a corresponding second step at a fair price. You can redeem your stock at the first step price, which gets you to the same place as the previous form. And then there of course the form that we used, which we've just discussed. I think that covers most of them.
Do you have a view as to which is better? Presumably ours is the better and more effective.
I think, in terms of what we were trying to accomplish, to take the heat off Delaware, to allow the vigorous control market to continue, but not in the form of some of the more abusive tactics, such as the really low ball offer or the front-end loaded two-tier offer. I think for us, Section 203 has been spectacularly successful. If you had asked me where I would have wanted to be after this was all over and had the benefit of hindsight, I think we took the pressure off the state. I think we offered some benefit in terms of the creeping thing that I mentioned, and I don't think anybody in hindsight could say that 203 inhibited takeover activity. We've had a tremendously vigorous takeover market over the last 30 years, and certainly any argument that 203 was stopping that, I think it has turned out to be. I'm sure those who made that argument many of them were making it in a good faith belief, but it turns out they were wrong.
Well, thank you, Mr. Sparks. That was very illuminating, and I really appreciate your efforts, not just today, but on behalf of the state of Delaware and our corporation law.
And thank you, Ed. You were a key part of all this at the time, and I appreciate everything you did also.